Imagine spending your entire childhood in your family home, learning to walk on that soil, knowing which tree bore the sweetest fruit, memorizing the cracks in the walls of the house your parents built with their own hands. That place shaped you. It held your laughter, your tears, your becoming. Now imagine after your parents are gone that it is no longer your home. Not because you did anything wrong. Not because you left. But because you are a woman. Or because you got married. Or because a meeting happened without you. Inheritance, for many Kenyans, is not just about property. It is about being cut off from memory, from identity, from belonging. One day you are a daughter of the land. The next, you are treated like a visitor. But the law does not see you as a visitor. The Constitution does not erase you. And your childhood does not disappear because someone says so. This episode is about that moment, the moment you're told you no longer belong, and the truth the law tells in response. Let's talk about succession. Let's talk about rights. Today we are unpacking one of the most important but often misunderstood areas of Kenyan law, succession law, the legal rules that determine what happens to a person's property after they die. In this episode, we'll explore 1. What the Law of Succession Act says. 2. Who qualifies as a dependent. 3. Who has the right to inherit. 4. Women's rights under the law, married or not. 5. Traditional practices versus statutory right. 6. What women can do if disinherited. The law of succession in Kenya. In Kenya, the primary statutory framework governing inheritance and the distribution of property after death is the Law of Succession Act, Cap 160, was amended by the Law of Succession, Amendment, Act, 2021. This law applies when someone dies intestate. That is, without leaving a valid will. Importantly, Kenyan succession law must be interpreted in light of the 2010 Constitution, which guarantees equality before the law and non-discrimination, Article 27, and specifically equal rights for men and women in marriage and at dissolution of marriage, Article 45. Who is a dependent? At the heart of succession law is the term dependent. A legal concept that determines who can inherit under the law when someone dies without a will. Under Section 29 of the Succession Act, as amended. 1. Automatic dependents. These people are classed as dependents without needing proof of financial support, the spouse of the deceased, husband or wife, recognized under the Marriage Act, 2014. The children of the deceased. Whether or not they were maintained by the person before death. This means that if someone dies without a will, their spouse and children automatically have legal rights to a share of the estate. 2. Other family members. Certain relatives may also be dependents, but only if they can prove they were financially supported by the deceased before death. Parents and step-parents. Grandparents and grandchildren. Stepchildren and adopted children. Brothers, sisters, half-brothers, half-sisters. To qualify, these relatives must show they were being maintained by the deceased immediately before death. 3. Former spouses and other claimants. Under earlier versions of the law, former wives or divorcees were included, but the 2021 amendment tightened this significantly. A former spouse is generally no longer classed as an automatic dependent unless they can show actual maintenance. What about husbands of deceased wives? Earlier law had a particularly discriminatory clause. Section 29(c), which said a husband of a deceased wife had to prove financial dependency in order to inherit her estate, while a wife of a deceased husband did not. This was struck down by Kenyan High Court in 2025 as unconstitutional discrimination. The effect of this judgment is to make inheritance rights more gender-neutral, affirming that spouses are dependents regardless of gender without disproportionate burdens. So, who has the right to inherit? Now that we know who qualifies as a dependent, let's look at how inheritance actually works. 1. Children. Under Section 35 of the Succession Act, if there is a surviving spouse and a child, the estate typically devolves among them, either equally or as statutorily prescribed. If there's no spouse, the estate can devolve entirely to the children. Crucially, Kenyan courts have held that sons and daughters are equal in rights to inheritance, and it does not matter whether a daughter is married or not. This is explicitly protected by the Constitution's anti-discrimination provisions. 2. Spouses. A surviving spouse has strong inheritance rights. They are treated equally, whether husband or wife. Spousal inheritance can include personal and household effects, a life interest in the matrimonial home if appropriate. Where there are multiple spouses, in customary or Islamic marriages, special rules govern their shares under Section 40 of the Act. 3. Extended family. Parents, siblings, and other relatives may inherit only if they fall within the defined category of dependents and can prove maintenance where required. However, and this is important, if there is no surviving spouse or children, that means the deceased person didn't have children or a wife, the law moves to the next level of potential dependents. These include the parents of the deceased, followed by siblings, brothers and sisters, and then half-siblings. Other relatives such as grandparents, grandchildren, stepchildren, and more distant relatives may also inherit, but only if they can prove that they were being maintained by the deceased immediately before death, as required under Section 29 of the Act. The guiding principle is dependency and closeness of blood relation, not cultural preference or gender. If a person dies without any relatives or dependents at all, Kenyan law does not allow the property to remain ownerless. Under Section 39(1) of the Law of Succession Act, the estate ultimately reverts to the state, the government of Kenya, through a process known as bona vacantia. The public trustee steps in to administer the estate, settle any debts, and transfer the remaining property to the government. This rule exists to ensure legal order, but it also quietly underscores an important truth. Inheritance disputes that exclude rightful family members are not just unjust. They risk erasing family legacy entirely. Which are the women's inheritance rights? What does the law say? 1. Daughters equal to sons. Kenyan law and judicial decisions are clear. 2. Daughters have the same right to inherit from their parents as sons, regardless of whether they are married, unmarried, or in a relationship. Courts have repeatedly affirmed that discrimination based on gender or marital status is unconstitutional. 3. Married women can inherit despite cultural belief that marriage extinguishes a woman's claim to her parents' property. This is not valid in law. Marital status does not strip daughters of their inheritance rights. A landmark case in which a Kenyan woman successfully argued she should be treated as a dependent and rightful heir to her father's estate confirms this principle, reinforcing that married daughters are entitled to inheritance from their parents. 4. Widows' rights. Widows have protections under both statutory law and the Constitution, including right to an equitable share in the husband's estate, right to continue living in the matrimonial home, protection from discriminatory customs. Kenyan courts have referenced constitutional guarantees of equality and dignity when upholding widows' rights. The reality versus the law. Customary practices. While the statutory law is progressive, customary practices sometimes still undermine women's rights, especially in rural areas. Examples: married daughters being told they belong to their husband's family and therefore forfeit rights to parental land. Widows being forced into wife inheritance or other practices that strip them of land and rights. These practices persist because of lack of awareness, social pressure, and weak enforcement. What women can do if they are disinherited. If a woman is wrongly denied her inheritance, Kenyan law provides several remedies. 1. Petition the court for succession rights. If a woman is a dependent under the Act and is excluded from the estate, she can file a succession cause in the High Court. The court can order distribution consistent with the law, regardless of custom. 2. Family protection claim. Under Section 26 of the Succession Act, if someone leaves a will that does not make reasonable provision for a dependent, that person can apply to the court for reasonable provision from the estate. This applies whether or not the deceased made a will. This is particularly useful where a woman is disinherited via a will. 3. Protection under the Constitution. Article 27, Equality, and Article 45 of Marital Equality strengthen women's claims. A woman can challenge discriminatory practices and seek enforcement of her constitutional rights in court. 4. Legal aid and advocacy. There are organizations and county bills, like the Siaya Widows Protection Bill, aimed at supporting women's inheritance rights and even criminalizing forced practices that lead to disinheritance. Kenyan succession law is structured to protect equality. Spouses and children are automatic dependents with inheritance rights, and courts have upheld the principle that gender or marital status should not limit those rights. Cultural practices may remain a barrier, but they do not trump statutory or constitutional rights. Women have strong legal tools, including court petitions and family protection claims, to enforce their rights if disinherited. Documentation matters. If possible, individuals should prepare wills and understand their rights ahead of time to avoid disputes. Succession isn't just about property. It's about dignity, fairness, and the protection of vulnerable family members in one of life's most difficult transitions. Understanding the law empowers families to uphold justice and preserve legacies.